Thank you for visiting my channel. Before we start, please hit the subscribe, like, and share buttons to receive notification of future presentations. Our topic is prejudicial question under Article 36 of the New Civil Code. Article 36. Prejudicial questions, which must be decided before any criminal prosecution may be instituted or may proceed, shall be governed by the rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. In one case, the Supreme Court said, a civil case to be considered prejudicial to a criminal action as to cause the suspension of the latter pending its determination must not only involve the same facts upon which the criminal prosecution would be based, but also that the resolution of the issue or issues in the civil case would necessarily be determinative of the guilt or innocence of the accused. In other cases, the Supreme Court further held that a prejudicial question is a question which arises in a case, the resolution of which is a logical antecedent of the issue involved in said case, and the cognizance of which pertains to another tribunal. It is a question of a purely civil character, but connected in such a manner to the crime on which the criminal case is based that it is determinative of the guilt or innocence of the accused. Elements of prejudicial question. Rule 3, Section 7 of the Rules of Court states the elements of a prejudicial question, to wit: A. The previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and B. The resolution of such issue determines whether or not the criminal action may proceed. In one case, the Supreme Court added another element, which is jurisdiction to try said prejudicial question must be lodged in another tribunal. The following are cases with prejudicial question. Merced versus Diaz et al., 109, Philippines, 155. Facts of the case. Abundio Merced, a married man, was forced by Elizabeth Cesar to contract marriage with her. He then sued for the annulment of the second marriage on the ground of force and intimidation, but Elizabeth countered with a criminal charge of bigamy. In his answer in the bigamy case, he filed a motion to suspend the criminal proceedings until after the termination of the annulment case on the theory that the annulment was a prejudicial question. Held. The annulment is really a prejudicial question because if he was really forced, there was no consent to the second marriage and he cannot therefore be guilty of bigamy. In order that a person may be held guilty of bigamy, the second marriage must have had all the essential elements of a valid marriage were it not for the existence of the first marriage. The contention that the second marriage, being bigamous and void, does not have to be declared such as held in People v. Mendoza cannot be sustained because precisely the issue here is whether or not such marriage was really bigamous. Another case with prejudicial question is APA versus R.F. Fernandez, GR 112381, March 20, 1995. Facts of the case. The information alleges that, without the knowledge and consent of the owner, Rosita Tigol, petitioners occupied or took possession of a portion of her property by building their houses thereon and deprived her of the use of a portion of her land to her damage and prejudice. Now, the ownership of the land in question, known as Lot 3635-B of the Opon Cadastre, covered by TCT number 13250, is the issue in civil case number 2247-L, now pending in branch 27 of the RTC of Lapu-Lapu City. The resolution, therefore, of this question would necessarily be determinative of petitioner's criminal liability for squatting. In the criminal case, the question is whether petitioners occupied a piece of land not belonging to them but to private respondent and against the latter's will. Held. A prejudicial question is a question which is based on a fact distinct and separate from the crime, but so intimately connected with it that its resolution is determinative of the guilt or innocence of the accused. To justify suspension of the criminal action, it must appear not only that the civil case involves facts intimately related to those upon which the criminal prosecution is based, but also that the decision of the issue or issues raised in the civil case would be decisive of the guilt or innocence of the accused. Another case with prejudicial question is Zapanta versus Montesa, GR number L-14534, February 28, 1962. Facts of the case. While the marriage between A and B was still subsisting, A got married to C. B filed a criminal action for bigamy against A. In the meantime, A filed an action for annulment of the marriage on the grounds of force, intimidation, fraud, etc. He further moved for the suspension of the criminal action on the ground of prejudicial question. Held, there was really a prejudicial question, as the resolution of the action for annulment of marriage with B was determinative of the guilt or innocence of the accused in the criminal case. In one case, the Supreme Court held that partition case is a prejudicial question to a criminal case for violation of PD 772. Presidential Decree 772 is the Anti-Squatting Act. It was repealed by Republic Act 8368 in October 1997. Facts of the case. A, B, and C are heirs of X and Y who left a parcel of land. A was able to obtain a title over the land, so B and C filed an action for declaration of nullity of the title and partition. Then they occupied a portion of the land without A's knowledge and consent. Hence, they were sued for violation of PD number 772, otherwise known as the anti-squatting law. Before they were arraigned, they moved to suspend the criminal action on the ground of prejudicial question. Held, the motion should be granted on the ground of a prejudicial question. A prejudicial question is a question in a civil case which is based on a fact distinct and separate from the crime, but so intimately connected with it that its resolution is determinative of the guilt or innocence of the person accused of the crime. In the criminal case, the question is whether B and C occupied a piece of land not belonging to them but to A and against the latter's will. Whether or not the land they occupied belongs to them is the issue in the civil case they previously filed for the nullity of A's title and for partition. The resolution, therefore, of this question would necessarily be determinative of B and C's criminal liability for squatting. In other words, whatever may be the ultimate resolution will be determinative of the guilt or innocence of B and C in the criminal case. Surely, if B and C are co-owners of the lot in question, they cannot be found guilty of squatting because they are very much entitled to the use and occupation of the land as A. Ownership is thus the pivotal question. Since this is the question in the civil case, the proceedings in the criminal case must in the meantime be suspended. The following are cases with no prejudicial question. Action for the nullity of marriage is not a prejudicial question to a concubinate's case. Maynardo Beltran versus People, GR number 137567, June 20, 2000. Facts of the case. Maynardo filed a complaint for nullity of his marriage with his wife on the ground of psychological incapacity. The wife filed a complaint for concubinates against the husband. In the meantime, the man filed a motion to suspend the criminal case on the ground of prejudicial question. He contended that there was a possibility that two conflicting decisions might result, where the court may declare the marriage valid and thus dismiss the complaint and acquit the accused because of the invalidity of the marriage on the ground of psychological incapacity. Held, the rationale behind the principle of prejudicial question is to avoid two conflicting decisions. It has two essential elements. One, The civil action involves an issue similar or intimately related to the issue raised in the criminal action, and 2. The resolution of such issue determines whether or not the criminal action may proceed. Dependency of the case for declaration of nullity of petitioner's marriage is not a prejudicial question to the concubinate's case. For a civil case to be considered prejudicial to a criminal action as to cause the suspension of the latter pending the final determination of the civil case, it must appear not only that the civil case involves the same facts upon which the criminal prosecution would be based, but also that in the resolution of the issue or issues raised in the aforesaid civil action, the guilt or innocence of the accused would necessarily be determined. Another case without a prejudicial question is People versus Aragon, 94 Philippines 357. Facts of the case. A forced B to marry him. B filed an action for annulment of marriage on the ground of force or intimidation. During dependency of the annulment case, A married C. Hence, A was charged with bigamy. A filed a motion to suspend the criminal action on the ground of prejudicial question. Held, the motion is not proper. If the cause for the invalidity of the marriage is due to his own malfeasance, he cannot avail of it to defeat the criminal case. He who comes to court must do so with clean hands. In this case, it was A who forced B to marry him. Hence, he created the cause for the invalidity of the marriage. Another case without a prejudicial question is Landicho versus Relova, 22 SCRA 731. Facts of the case. A and B are married. During the existence of their marriage, A married C. B filed a complaint for bigamy against A. C, in the meantime, filed an action for annulment of marriage. In his answer, A filed a third-party claim for annulment of marriage against B and moved for the suspension of the criminal action on the ground of prejudicial question. Held. A should not decide the validity of the marriage. Let the court decide it. If it is not declared void or annulled, the presumption is that it is valid. Anyone who contracts a second marriage runs the risk of being prosecuted for bigamy. Another case is Donato versus Luna, GR number 53642, April 15, 1988. Facts of the case. X and Y are married. During the existence of the first marriage, X married Z. A bigamy case was filed by the second wife. In the meantime, Z filed an action for annulment of marriage on the ground of fraud. X filed an answer contending that the marriage is void because it was solemnized without a marriage license and that his consent was obtained by force and intimidation, and at the same time moved for the suspension of the criminal action on the ground of prejudicial question. Held. A prejudicial question usually comes into play in a situation where a civil action and a criminal action may proceed because however the issue raised in the civil case is resolved would be determinative juris et juri of the guilt or innocence of the accused in the criminal case. The case here does not show a prejudicial question. It was the second wife who filed the action on the ground of deceit. The reliance on Landicho versus Relova is not proper. The mere fact that there are actions to annul the marriages entered into by the accused in a bigamy case does not mean that prejudicial questions are automatically raised in civil actions as to warrant the suspension of the criminal case. If you find this presentation helpful, please hit the subscribe, like, and share buttons to receive notification of future presentations. Thank you.